All right, hello everyone. I think we're going to go ahead and get started. Thank you for joining us for our panel on proxy voting. My name is Sarah Buescher, and I'm Associate General Counsel with the IAA. And I'm delighted to have two wonderful panelists here with us. To my left and your right, Scot Draeger is President and General Counsel of RM Davis, an independent investment advisory firm. And Scot joined RM Davis in 2017, and before that he had senior roles on both the legal, business, and management side at Citigroup, at the SEC, and at the law firm Bernstein Shore. Scot's also a member of the SEC's Asset Management Advisory Committee, and he participated in the SEC's roundtable on proxy issues in late 2018. And on my right, your left, is Bob Plaze, and Bob is a partner in Proskauer in their registered funds group. And Bob provides advice to investment companies and investment advisors on all range of legal and regulatory issues. And previously, Bob was Deputy Director at the SEC in its Division of Investment Management, and he worked on a wide variety of policy issues, including, for purposes of this panel, the Advisors Act proxy voting rules. So we are delighted to have Scot and Bob with us. Steve Yadagari of Kramer, Rosenthal, McGlynn was scheduled to join us, but unfortunately he was unable to attend. So we've got a small group here, so please feel free to ask questions or add observations as we go along. That's gonna make it more interesting. So there's definitely been a lot of recent activity, particularly from the SEC on proxy voting, but what we thought we would start with is just giving some background on what's already out there, because I think people think it's all new, and it's not. There's plenty that's been out there for a while, and Bob is gonna get us started with that.
Nothing is new under the sun or the moons, right? And all three of us were colleagues together at the SEC and knew each other well a long time ago at this point. Proxy voting. One of the things I find most interesting about proxy voting, I may be the only person who finds it interesting, is that the Commission said virtually nothing about advisors' obligations regarding proxy voting until 2003. That's, 63 years after the Advisors Act before the Commission. Now, there's a sentence in the Institutional Investors Report back in the 60s alluding to it, but virtually it said nothing about it. And so when the Commission, and I was privileged to be there at the time, was asked to take a look at proxy voting on the sell side. Now, of course, we're very active under the Exchange Act, regulating the whole proxy voting system between issuers and broker-dealers and proxy solicitors and the people who participate in that system. That's been active since forever, but not on the sell side. That was 2003, and I have a theory about this I'll offer later. We discovered this, and basically, in addition to writing the rule that you know, basically we had to, at the time, the Commission did in that release in 2003, it's a decent read if you want to go back to it. And by the way, it's a lot shorter than some of the ones you've been reading coming out of the Commission later. If you try the 500-page advertising rule, for example. This is 20 pages or so. And basically, the rule has three elements. Requires each advisor to develop policies and procedures reasonably designed to ensure that the advisors vote proxies in the best interests of clients. Disclose, that by the way, that the rule precedes the compliance rule, because if you think about it, that would be entirely subsumed in the compliance rule today. Your compliance policies and procedures need to address proxy voting if you have authority to vote it, but it's the sequential order of the rules what matters here. And generally speaking, the compliance rule release talks about proxy voting policies as part of the general overall policies and compliance policies and procedures of an advisor. Secondly, to disclose information about how advisors vote their securities, vote the proxies, and to make the proxy voting policies available to clients upon request. There's no requirement to disclose how the client's proxy, you voted the client's proxies. The Commission was concerned that would give out, in some cases, confidential information about client holdings, in particular advisors who had a few large clients. The rule, so, is procedural, but in the course of adopting it, the Commission discussed the application of fiduciary obligations to proxy voting. The Commission had never said that voting a proxy had fiduciary implications before 2003, and it laid it out in that release. And it discussed the obligations drawn from the fiduciary duty as involving both the duty of care and the duty of loyalty. Those two duties, which played a significant role in the latest standard of conduct release last year, that's all drawn from the proxy voting release in 2003. The duty of care requires advisors with proxy voting authority to actually vote the proxies, and the Commission made clear, something that's been reiterated several times now, that that doesn't mean you have an obligation to vote all of the proxy statements, but rather you have an obligation not to be negligent in undertaking the duty that you've assumed to vote proxies. And that in evaluating what that duty is, one can take into consideration both the costs and the benefits of voting proxies. The costs, the example that's always used is a proxy you get from a foreign issuer in another language. The cost of voting that proxy probably way exceeds the benefits to the clients. But in private practice, I've come across situations where the benefits aren't on the benefit side of the ledger. For instance, this happens all the time. The client has already sold the security and held the security when the record date passed. No benefits to voting that proxy, or if you intend to send the proxy. So I think the Commission, although laid out the obligation, was reasonable in terms of its application. It's also very similar to the position the folks at the Department of Labor took for years in terms of voting. Duty of loyalty. The Commission recognized that there were conflicts of interest that can arise, particularly where an investment manager manages money for a company whose proxy it's being asked to vote, and indicated that those conflicts would have to be addressed under the Advisors Act. Commenters in the proposing release, I recall asking, well, how do we do that? I mean, it's not like we can go out and give the disclosure and consent for every time there's a proxy we vote. It's just simply not practical. And so the Commission laid out a couple of alternatives for advisors to do, and I think you all do that, one hopes. One is if you have specific policies and procedures on how you vote securities, you're relieved of a conflict to the extent that you vote them in accordance. Of course, it has to be fairly specific in terms of how you vote. The second thing is to obtain, to default to an independent third party. It didn't refer to the proxy voting advisor as is the current releases, but it did talk to an independent third party. And to give you an example of how that works every day, and people don't think about it, is advisors have sub-advisors to whom they delegate proxy voting authority. And the large asset managers, I know it's prevalent in the mutual fund industry, but by divesting themselves of proxy voting authority, the fact that they may have a conflict on a particular proxy that the sub-advisor is voting, they don't have the conflict themselves. They've divested themselves of that conflict, and the sub-advisor can go ahead and vote it accordingly. In essence, deferring to the proxy voting service, proxy advisor service, this is the same thing. It says, I have a conflict, I'm not voting, I am, in this particular instance, I'm going to vote in accordance with the recommendations or a third party, or I may just give power of attorney to the proxy voting authority to do that. And so I think that makes a lot of sense. Now, after the release came out, the issues were raised in terms of proxy voting advisors. And the interesting thing, the issue was between the proxy voting advisors themselves. There are two letters, one to Egan-Jones and one to ISS, arguing about where you can be an independent, where you are an independent proxy advisor. And ISS had some conflicts, and Egan-Jones wanted to point that out. And I think some staff letters went out and indicated that an advisor relying on a proxy voting advisor in those circumstances had to pay attention to the conflicts of interest, that it was really an independent advisor. These didn't seem to be significant rules. But there was a roundtable later on in which, I think it was in 2010 sometimes, the first proxy voting service, in which there were a lot of complaints from corporate managers, particularly the Chamber of Commerce, who was at the time represented by Harvey Pitt, the chairman who was presiding at the commission when the proxy voting rule was adopted, who complained bitterly about proxy voting advisors and about these two particular releases or letters, staff letters, that seemed to give proxy advisors a huge amount of power with respect to how corporate proxies are voted. Of course, they didn't. The releases didn't. They dealt with a conflict. The release basically blessed using proxy voting advisor like a sub-advisor in terms of dealing with conflicts, was consistent with traditional advisor fiduciary law, but yet we began to see the rumblings of what was to happen later on. Indeed, in, I believe it was 2014, the next event occurred where the staff issued guidance about proxy voting. There's generally proxy voting guidance in general, but the only things that were new in that proxy voting guidance was proxy advisors, right? Most of the guidance that was issued was repetitive from things in the release or things in the letters. The 2 letters were withdrawn, and some guidance was issued that was codified into a staff bulletin in 2014. And it talked about the selection of a proxy advisor service, that when decided to retain a particular proxy advisor firm, an advisor needs to ascertain whether the advisor has the capacity, competence to adequately analyze the issues. I think a number of corporations felt that they didn't or they weren't. But of course the issue really, fiduciary, is do you have a better capability of doing that than they do? That's the real choice, of course, presented. Secondly is recommendations based upon current and accurate information. I always thought they based their recommendations on information provided by the issuer of the security. But then again, there are disputes in that area too. And 3, whether they've identified and addressed their own conflicts of interest, which is interesting in the question of ISS, which clearly has conflicts. They presumably, they assert that they use information barriers, the same methodology that all the investment banks in New York use in order to separate the buy side from the sell side. They provide consulting services. And the question is whether those are adequate. The 2007, the Congressional Research Service did a study at the behest of some member of Congress on proxy voting advisors, and found that their clients, the investment managers, were happy with their service and didn't find problems or didn't find failures or inaccuracies. And 3rd, described the information barriers used at ISS and indicated that they did not find indications that there were violations of those barriers or that those conflicts were not managed appropriately. All of this is a prelude to what's happening in 2019.
Right. So as you can see, this issue has gone through a lot of twists and turns. And I think one thing that distinguishes this issue from some others that the Commission has dealt with, it is highly political. And that's why you see, you had these no action letters, then the staff legal bulletin. Now those letters have been withdrawn. But one significant development that came in August of last year is that the SEC issued guidance for investment advisors on proxy voting. And so I'm going to turn it to Scott to get us started on that.
Thanks, Sarah. And thank you all for being here. I know that if proxy voting doesn't get your blood boiling, nothing will. So we realize it's not the sexiest topic. And given the truth in that, I'm going to start with the politics of the issue first, and then I'll work backwards to the mechanics of how you all go about kind of tying the relationship together between proxy voting and your fiduciary duty, and what are the compliance things that you need to have on your list and to-dos. But the politics of the issue is worth mentioning. Things change, but they stay the same. When we were together at the Commission, in the prior century, literally, the politicization of the issue of shareholder access, corporate boardroom, corporate issuer versus, the shareholder activist community, institutional investor community. Those issues were all present. This is what we're seeing now is just a new form of presentation. And so the politics of the issue, for those of you who work with the ISS or Glass Lewis or others, you realize that they quote unquote control a meaningful percentage of the ballots for proxy voting, and the shareholder activists and institutional investor community, as they have always done, have pushed for changes. And today's version of changes include things that you're all aware of: environmental responsibility, social responsibility, diversity, say on pay, executive compensation restraint, so on and so forth. That's a really big pain in the butt for the corporate issuer community, especially when you're talking about executive compensation. And the closer you get to executive compensation, the more lobbying and pushback you get against the influence of the activist community. So, Bobby, you were going to say something.
Yeah, just to riff off of that because it's just so good. You know, there's a lot of criticism about asset managers and their stewardship of their customers, their clients' proxies. Well, the fact that the corporate managers and corporate community are pushing back suggests you might be doing something right.
Yeah, sunshine is the best disinfectant, and all of a sudden the light is bright. So the issuer community through the Business Roundtable, the Chamber of Commerce, American Enterprise Institute, and the others have put a lot of money into lobbying both on the Hill and at the Commission, and have found open ears on the issue. And so what has resulted is staff guidance and Commission interest in allowing the issuer community to have a greater influence over the processes at ISS and Glass Lewis and with the proxy voting that unfolds as a result of their services. And so I think that by and large our community, the investment advisor community, 99% of us probably feel like this is fairly misguided. And now that Bob and I are no longer on the staff, we have the liberty to share our own personal opinions without
consequence.
Consequence, yeah. So now proxy advisory firms, the big issue for all of us is how much are we going to be able to continue to rely on proxy advisory firms to help us fulfill our duties? And as a result of the guidance, the proxy advisory firms now are required to allow the issuers to take a look at things early and have a greater influence on the recommendations that they're making to all of their clients, which include you all. IAs rely, the guidance would have IAs rely less on the ISSs and Glass Lewis's of the world than taking more initiative independently to do the work. That's what the releases would lead one to believe the Commission's purposes. The Commission, I think, is missing the realities, which are the use of the proxy advisory firms furthers rather than detracts from the fiduciary duty of care for most advisors. You know, speaking for my own firm, I know that the resources that we get from those firms, and they're not perfect, and there is a lot of diligence you have to do, but the resources we get are exponentially greater than we could ever develop internally on our own, and we use those resources to fulfill our fiduciary duty. And the reality is that 95% of votes are not controversial, uncontested, and it's easy to rely upon the services for a lot of the things that are less meaty. So the cost-benefit analysis wasn't really done either, which was a big concern, I think, to our community, because this is getting more and more expensive. I've done some math, and speaking generally, for every 2,500 accounts you have with 100 equities, it's going to cost you $100,000 a year to deploy the resources of ISS or Glass Lewis. That's not an insignificant amount. That's an extra employee that could be hired. So these costs are going to rise. And are those costs really being well balanced with the fact that this is really an institutional issue? So a lot of you that have retail clients, I expect that you may indeed feel like most of your clients could care less about proxy voting, or their main question for you is, I'm not going to get all this crap in the mail, am I? You're going to take care of that if I hire you. And so some of those realities, the current policies that are happening are a little disconnected. That's not true in the institutional community. I think there's a very, very earnest interest in all of this in the institutional community, and a growing interest in the retail community with the ESG and stuff. But the politics of the issue, things change, they stay the same. Commissioner Lee had a great dissent to the recent releases. She spoke, this morning, and I think the concerns that she expressed with it are really hitting the nail on the head. So she expressed that the proxy release weakens shareholder voting rights, that it reduces the proxy advisory firm's independence from the issuers, which is really the glaring conflict of interest that we should be concerned about. It increases the cost and time pressures on the RIA community. There's no notice and comment, no cost-benefit analysis, no economic analysis, all administrative law grounds on which commission action has been successfully challenged in the past. And it's really an effort to kind of weaken the utility of proxy advisory firms, which could lead to mid and small-sized firms deciding not to vote proxies at all, which Bob made the point. There's no legal obligation that proxies must be voted. If your contracts, policies, procedures, and disclosures all say that you don't vote proxies, then that's something.
And there was a discussion in the release or in the guidance about contracts and not voting proxies that was sort of unnecessarily obvious, and sort of gave you an indication of what some at least people writing the draft release was really interested in, going back to the modern age in which proxies were voted by individuals, and institutions simply accepted the Wall Street rule in which they voted with management, and so they didn't have to spend the time or the resources to vote proxies. I think if you peer deep into the hearts of the issuer community, they want to go back to those days when America was great, and in which their compensation packages were not challenged.
I would say in terms of the practical, some of the questions that we got from members after the guidance came out, there's some Q&As in there, like Bob was saying, about scoping out the agreement with your client on whether you're going to vote proxies, and they give some ideas. Are you going to agree that you're going to vote with management or vote with shareholders on proposals, or you advisor are not doing any proxy voting anymore? And we got a lot of questions back where people reviewed their agreements, the Form ADV, policies and procedures and practices, and they found some things that didn't agree. For example, one member called in and said, well, right now in my ADV it says that we don't vote proxies, but we'll provide advice to clients on how to vote proxies upon request. But then when I checked with my policies and procedures and talked to my other staff, there wasn't nobody knew what that meant. Okay, so if a client calls and wants advice, what do you tell them? Well, there wasn't a clear answer there. So they kind of gave that as a cautionary tale to say this is one area to look at. I think another area that I heard about from a couple of other people are situations where they vote ERISA, they only vote ERISA client proxies, nobody else, and what they said in their ADV is we do not vote proxies at all. Well, wait a minute, yes you do. And I do think, like to Scott's point, a lot of that guidance was around use of proxy advisory firms and are they having enough engagement with issuers. And I got to say, I feel like the biggest area for OC to go and check is not so much did you talk with the proxy advisory firm on how many times they engaged with Acme Widget Company last month. It's look at your disclosures and policies and procedures and do all of these and practices, do all these things agree with each other? It's do what you say and say what you do. And there were a couple of enforcement actions that came out a few months ago against advisors around proxy voting, and it was just around that. They said that they did not do proxy voting, and they were approached by a broker who asked them to vote proxies, and they did. And so that was the enforcement action. So I think that the whole scoping of agreements, that's one area where we've gotten some member feedback. The other thing in the guidance that has raised questions is there's a discussion in there about whether you need client-specific proxy voting policies. And so we've gotten questions, well, all of my clients follow a similar strategy. We're large cap growth, and so why do we need, things by client, policies by client? And I think our response to that is you may not necessarily need that, but perhaps if you have a situation where a client is more focused on ESG investing, or you have clients in a different type of perhaps a contrarian strategy, then maybe you do. But I would say those are a couple of areas. The other thing is they talk about issuer-specific reviews in the guidance. And again, that may be more around M&A situations and things like that. But I would say kind of scoping agreements and also the client-specific issues. Those were two areas that came up outside the proxy advisory firm guidance that we heard feedback on.
The other thing to think about is the new guidance, which indicates what you should do before selecting a proxy advisor and how you should do oversight of that proxy advisor. Think real hard before you put in your policies and procedures, word for word, what the SEC says at its release, because they will hold you to that. The SEC release, the guidance, seems to be predicated on your delegation of authority to, in terms of materiality, in terms of merely one input. Let's say you get input from lots of places in terms of how you make your buy and sell decisions as well as your proxy decisions. Do you have to go back down and check the Wall Street Journal to see that its journalists have gotten all their facts right before you rely on an article? If you simply use proxy voting services, one input to many in which your committee, if your people use, does basic thresholds of materiality require you to do the type of things that the SEC is saying in this release? And the question is, what are your examiners are going to say when they come in? We'll find out. But be careful what you take out of the release and put into your policies, because regardless of what happens with the SEC guidance on this lawsuit, you will be held. You will be held to do what you say.
Yeah, what Bob said is very true across the board on policies and procedures. So just so we don't fail to give you some takeaways as well, so what does it mean to tie your fiduciary duty to proxy voting? Sarah touched on a few of these points. The first is scope of your voting authority. So having that agreed, in your agreements, in your policies, and in your disclosures, and you really have some flexibility there. You can state outright that you can agree with your clients to vote generally with management, except for pulling a few things off the table, such as corporate transactions, M&A, share buybacks, say on pay, or big issues that you're going to agree with all your clients, are the ones that you feel like you have the resources to pull offline and dive into. So it's incumbent upon you to decide where you want to draw the lines, and then very importantly, tied to Bob and Sarah's points, make sure that you have the internal ticking and tying that's actually being done, because you wouldn't want to implement policies that are intended to demonstrate that you're doing some of this on your own, independent or in excess of ISS or Glass-Lewis, and then lo and behold, it's not actually getting done. And then some of the other things to be careful of include, to Sarah's point on individual clients and what matters to them, or individual strategies, you do have to do some thinking there. If you're an income shop and you have a strategy that's heavily reliant on dividend-paying stocks, then the fact that you're not voting against share buybacks may raise some eyebrows. So, if you do have to kind of look at what your strategy is, what your clients' interests are, and then are the proxy policies aligning with what the obvious, what would be an obvious furtherance of your client's stated objectives or your strategy's stated objectives. And then you can utilize ISS or Glass-Lewis to implement those things in a way that's prudent. So the scope of services, understanding the client objectives, make sure your voting determinations are based on complete and accurate information. So this is the part, as Bob was discussing, if you're deploying a proxy advisory firm, the commission's trying to have you make sure that you're comfortable that they're getting all the complete and accurate information, and there are no material omissions. And the commission's current version of that means make sure that they're getting additional input of the issuer community before they make their recommendations. Right.
So, they sort of suggested that, but without saying it. That the saying it comes in a later rulemaking, and it's an imposition on them. So what are people doing? I must tell you, I have not had a lot of calls from clients. I think clients right now are sitting back and watching the fight go on and see what happens before making a move in this area. Do you have to go in and do a look through ISS and find out where they're doing? One, again, the question, if you use this as an input and not relying on advisors, I think that the obligations that the SEC could bring in enforcement action on for breach of fiduciary duty are very different. And so you take that into consideration in terms of what you do, although your examiners may feel differently. You may have some discussions with your examiners. about that.
And some of what they said is consistent with some of the earlier staff legal bulletin. You know, they talk about reviewing the adequacy of the staffing and things like that. Like, that's not so new. But to your point, Scott, it's this whole idea of issuer engagement, which Commissioner Lee mentioned, and you know, in her dissent on this guidance is just kind of a new concept.
The irony of it is that, you know, before this release, and even in discussions I've had with the exam staff after the release, when we would do our day's worth of diligence on ISS at our firm, it would be in major part targeted to understand their conflicts of interest, with situations where affiliates of theirs are doing work for the issuers, and similar, analogous to, you know, auditor independent issues or rating agency issues. And so if they're being paid to do something over here, making a lot more money on it than they are off the proxy voting services over here, then does GE have too much leverage over them relative to the recommendations that they're making on GE proxies? And so, you know, historically, we viewed our diligence as in part rooting out those sort of conflicts of interest. And now it appears to be flipped on its head, where you're going in and saying, have you really, I want to make sure you don't have a deaf ear to the issuer community. It kind of feels like saying to the rating agencies, before you've decided to go with just below BBB, have you gone and checked with the issuer to make sure they can't talk you into investment grade? You know, like, so everything now, the form of diligence seems to be flipped on its head.
Well, and it's so result driven, because advisors every day make decisions whether to buy and sell a security, which is ever so more a significant decision for their clients. But no one has ever suggested, no one from the Commission has ever suggested in making a decision to buy or sell, one has to diligence the company. And could you go to the company and say, listen, I'm thinking of selling your stock, but I'm willing to talk to you about not selling it. No, in fact, people sell stock based upon a hunch that it's going down, right? That I have a sense of the way the market is. And, oh no, but when we're voting proxies, votes which are of significantly less significance to investors, now we've got to go and do that. The real story is that those votes, proxy votes, are not so significant to the investors. They're significant to the management of the companies who are petitioning the SEC and whom the SEC is responding to. In fact, they're asking you to due diligence a security that might have a fraction of a % of a portfolio. They're in the release, although the beginning of the release discusses a decision whether or not to vote a proxy depends upon cost-benefit analysis. As soon as the release meanders into discussion of how you deal with proxy advisors, we all lose all sense. There's no cost-benefit. There's things that you should be doing as fiduciary and things that you shouldn't. So if you hold a very small amount in some company's stock, how you vote that security probably is completely immaterial to achieving the investment objectives of your clients. And so you have to, that's why I think you have to take at least the advisor's obligations with a grain of salt in terms of what the SEC is able to do with this.
Yeah, so I guess some good news and some practical tips as well. In some ways, this hasn't changed as dramatically as it feels for the nerdy policy wonks, the three of us that are so interested in it. It's always been the case that if you're going to use proxy fund advisors, that you had to understand what they're doing, diligence. It didn't alleviate any responsibilities or obligations that the advisors have to actually make sure the votes are cast in the best interest of their clients. As a practical matter, with a combination of the right contractual provisions, disclosures, and policies and procedures, there remains the latitude to make substantial use of these firms and their products. So the list, the Commission at least has kind of outlined for you what your diligence letter should look like to ISS or Glass Lewis. So they've said you need to ask these questions. Does the proxy advisory firm have capacity, competence, analytics, staffing, and tech to do the job? That's pretty easily answered with these two mega firms. Does the proxy advisory firm have a process for seeking timely input from the issuers? We'll talk about ISS's lawsuit in a few minutes, but I think what you'll find is indeed they do. And how does the proxy advisory firm account for now this is really targeted at executive compensation. So how does the proxy advisory firm account for unique characteristics of each issuer when comparing them to their peer group, including when talking about say on pay? So, it's not enough to look at all the companies in one industry and decide that somebody's overpaid. There's got to be some unique reason that justifies that pay and why you shouldn't be opposed to it.
And therein lies the emphasis on errors or improper analysis and analytics, methodological weaknesses. So one of the big issues in proxy votings is comparatives. Who do you compare the company and its compensation of its CEO? What other companies do you compare? And people have these huge disagreements of these, right? And ultimately, the proxy advisor has to choose comparatives. In the same way, us in the mutual fund industry, Morningstar ends up picking in the 15C process the comparable funds and the expense levels. This is the desire for somebody to regulate or to get involved in the comparables. So what's actually going to happen here if the rules are adopted? Does somebody complain about the comparatives?
Yeah. And I think it's
a mistake.
This is something that our industry should be able to relate to a little bit, only because I view this, the idea that there's no comparable to what the executives at GE, should be, how they should be compensated. The rest of the industry is irrelevant. It's the equivalent of all of us saying, well, there really isn't any benchmark that's perfect comparison to our firm's performance because, it just is. But yeah, 90% of our stocks are in the S&P 500, but that's not really a great. That's bad methodology.
So that was
if you're going to compare
the MD&A and the mutual funds. I don't know if any of you are involved in the mutual fund industry. That was the argument. Remember, it requires you to compare your performance to a widely traded index, and basically the way the commission dealt with that back in 1998 or something, 1990, it says, well, the S&P 500. Well, you will be just use the S&P 500. You'll be safe. Then you can pick, and you can pick an extra one if you want to, and so. But anyways, these are ultimately judgment calls here mixed.
So the guidance is what's out there now, and for investment advisors. And we do have a webinar on our website, on the IAA website that we recorded. So that also has some more detail on it. So I think in the interest of time, we're going to move on to other guidance and also a proposal that at the same point that the SEC issued guidance for investment advisors, they issued a guidance and an interpretation around proxy voting advice, and also after that they issued a proposal around proxy voting advice. And so Bob's going to start us off there.
Yes, these are regulations that will not directly affect you, but they will directly or indirectly affect you, because I think the goal is to dramatically change the business model or end the business model of the proxy advisors. After that guidance was issued, ISS filed a lawsuit in claiming that violated a number of things. First of all, said the commission was out of the guidance that the commission put out in 2010. Nobody noticed. August of 2019, people noticed for the first time, said that the proxy voting advice constitutes a solicitation. So proxy advisors are solicitors under the proxy rules under the Exchange Act, and therefore they are subject to the anti-fraud provisions of 14A9, Rule 14A under the 34 Act. But they were exempt from the disclosure requirements. Proxy solicitors have to submit their proxy solicitation material to the commission. And so this was an interpretation, goes back now to 2010. Nobody's paid too much attention to it. But now the lawsuit challenged that interpretation. It said the commission was acted without authority to do so because proxy solicitors are clearly different than proxy advisors. Proxy solicitors is soliciting for a purpose, whether its own purpose or somebody else's purpose, to achieve a goal. A proxy advisor is giving advice with regarding to the optimal voting of proxies on behalf of its client who's giving advice. So it doesn't. That interpretation can't be upheld. It's irrational. Secondly, that this was really a notice and comment rulemaking, and that without should have been done by a notice and comment rulemaking. It didn't. And finally, it was arbitrary and capricious. Where did they come off changing the rules in the game all of a sudden after all of these decades of time? The lawsuit was filed in the District of Columbia. The plaintiff, ISS, agreed to hold its complaint in abeyance for a period of time to allow the SEC's rulemaking proceeding on the same subject matter to go forward, which began in November, I believe, of 2019. So that lawsuit's in stasis. But the rulemaking, which probably should have been done in first without this interpretive guidance, their constituency groups were perhaps anxious about getting it out soon. The rulemaking goes to exactly this point. The term solicitor or solicitation is not defined in the Exchange Act. It's a creature of SEC rules, and they've amended the rule in such a way as to capture the proxy advisors. And they've done so differently from the guidance, which picks up sub-advisors. You know, if anybody thought about it, it would have picked up everybody. And this one clearly goes down and says, might as well just put ISS and Glass Lewis right in their names. So it picks them up. It also subjects them to a number of regulatory requirements, but the one that has everybody, two that has everybody worked up, and we'll deal with the interest of time we'll deal with. One is it requires it does this. Remember, there's an exemption from the disclosure requirements, the filing with the SEC. And for proxy advisors, if they had to disclose their proxy voting advice every season in a public filing to the SEC, their whole business model would collapse, because who would pay a subscription if they could just go on the SEC's website and get it? So although the rule is styled in terms of an exemption from the disclosure requirement, it's not something the proxy advisors can just take advantage of or not. And of course, everybody knows that. So, failure to follow this would threaten the proxy advisor's business model. And it requires proxy advisors to give issuers not just one, but two, ability to twice review their recommendations and to get, quote, feedback from the corporate issuers on the regulations. Secondly, and this is very too much tied in terms of its impact on proxy voters, it amends the proxy fraud rule to clearly pick up proxy advice in some very technical ways that will have an impact on proxy advisors and will expose proxy advisors to liability. Now, proxy advisors are like the mouse, and you can think of each individual corporation like, you know, a Goliath here. So the question is, during this give and take, that where there's a disagreement, as there would be, and as users of these proxy advisory services, you would expect there to be disagreements, because you want your proxy advisors to give you advice to vote against some pay packages. Maybe not all of them, but certainly some of them. The issue is whether there will be potential litigation or a potential SEC Division of Corporation Finance phone calls to the proxy advisor, to its clients, about the mistakes they used on the compromise. So what they've created here is two things. One is they've created a chilling effect on that advice. And secondly, they've created a series of hurdles and procedures through which the proxy advisor has to go through that's going to compress the time available in proxy season for which the proxy advisors to consider the issues, and for the for you, the clients of the proxy advisors, to receive and be able to digest and understand the advice that you're getting before you're required to vote. And there's a great deal of concern in the comment letters on this, and I know IAA wrote a very good comment letter on it, that this is going to result in more errors and not less errors, because everybody has this. I mean, there's a huge number of proxies these firms have to deal with in proxy seasons.
Yeah, we made the point, this is, you know, they should focus on proxy plumbing or infrastructure, right, not this. Basically, it's a solution in search of a problem. This whole issuer review is not going to work logistically, and also it doesn't work from an independent. People want independent advice. They don't want it shared with the issuer. So, I mean, there have been thousands of comments on this, so it's going to be interesting to see where this goes. But a lot of what Commissioner Lee said this morning was consistent with our comment letter.
And there's a real divide in the comments between the business interests and the asset managers. Yes. I read the Business Roundtable comment letter this morning and said it's fine, but it wants the rule to require the proxy to force them to change their websites so that it is physically impossible for an investment manager to agree to vote proxies in accordance with the guidelines.
And we actually commented against, because the SEC requested comments saying, should we disable these automated voting platforms? And we're like, absolutely not. You know, this is a business process. Why in the world would you step into this? So it's been a very unusual process.
But you can manage a portfolio according to an index. Think about it, by a third party choosing an index. But you can't you can't vote your proxies in accordance with essentially ISS's guidelines, which are an index, having concluded that the guidelines are guidelines that you as a money management firm would follow if you had the opportunity to follow. This doesn't make a lot of sense except to a corporate issuer.
There's so many layers of intellectual dishonesty,
right,
you know, baked into it. You know, Neil and Sarah and everyone at IAA did a fabulous job with the comment letter, which basically advocates for what most advisors feel. You know, two things that are very interesting to me are so the case that was filed in the DC Circuit, typically it's the Chamber of Commerce, American Enterprise Institute, this whole kind of gang, if you will, that files lawsuits against the commission saying that the regulations were made in an arbitrary and capricious way because notice and comment rulemaking wasn't done, they didn't do economic analysis, all this other stuff. Now we're on the opposite side. They are saying, oh, none of that was needed because we got exactly the result that we wanted on the first try. So it's just, that's really, and then the other thing is the Investor Advisory Committee work was really good in showing that, you know, emphasizing what Sarah said, this is a solution in search of a problem. So their research showed that for S&P 500 companies, there is about one shareholder proposal a year. And then for Russell 3000 companies, there's one proposal every 3 to 4 years. So, like, you know, but what is that proposal? Executive compensation. Yeah. So that's what it all kind of boils back to.
But what's going on in a larger context is that you money managers now own or control a good portion of the public float of companies in America. Individuals don't own these companies individually. They own them through financial institutions that have enormous power in terms of voting proxies. And this should be seen, I think, appropriately as a chapter playing out of tension, a struggle between the owners of capital and the managers of company, and that whose interests ultimately will prevail in the long time. I predict that if this were adopted before the end of this administration, which it very well might be, I don't know if the lawsuit will survive the rulemaking, but I predict that if a Democratic administration, this just talks about the politics, the Republicans seem to have lined up on the side of the business managers. The Democrats seem to line up on the side of the investment manager, investor community, largely because the largest voice in the room often is the public pension plans, which have been quite tied into Democratic politics for some time, and a sympathy. So you see everybody lining up and choosing teams, just like flag football or, you know, the primaries. It's the same thing is coming out here, but it's all over who has what to say in terms of how public companies are operated. It's a huge mega issue, and this is this is a skirmish on one part of that. Yeah, and there was also a proposal around shareholder proposal thresholds, which we did not comment on, but same people are kind of lining up in different ways. But so in the interest of time, let's move on to, you know, there's been a lot of SEC developments, but what are some compliance and business considerations around voting proxies? And Scott, I'm going to turn to you for that.
Sure. Well, I think in general, the key is to say what you do and do what you say. You know, as borrowing one of Sarah's lines, the risk of any, you know, enforcement action or anything that could have a material consequence on your firm's reputation or balance sheet is really small, and it really is confined to cases where there's a major inconsistency between your contracts, policies, and disclosures and what you're actually doing. And so if you, as a compliance officer, go back and focus your attention on making sure that those things are aligned, that the resources in your firm are being deployed to do what the policies call for, and then you deal with some of the practical issues that come up. So for instance, if you don't normally vote proxies, but you have a handful of clients that want you to vote proxies, making sure that you put something thoughtful around that. I mean, you have a duty of loyalty, so if you're going to be doing something for one client, doing it also for similarly situated clients is something that you're going to have to think about. You know, in the ESG space, you know, and the social responsibility space, I think there's a rapidly developing concern about an inconsistency between what advisors are saying and what they're actually doing. Some of the initial work of the Asset Management Advisory Committee that I'm on, a lot of the presentations focused on what a new term to me is called greenwashing. So there's a lot of advisory firms saying that they have an ESG or SRI strategy, or they have policies and procedures that reinforce that their style and form of investing is quote-unquote sustainable investing. And but the reality is the stocks being held, the way proxies are voted, et cetera, really is not materially different in those quote-unquote green strategies than it is in the garden variety standard strategy. And I think the Commission is starting to really pay attention to that, and they want the AMAC to focus some time and perceive the Europeans as way ahead of us on this stuff. And I think that'll bleed over into proxies as well. Because if you're a green strategy and you're not voting against, and you're voting against a shareholder proposal on environmental responsibility on Exxon, then those things aren't going to look very aligned.
Yeah, there was an article I appeared, I believe, in the New York Times some months ago about a firm that voted against all the ESG proposals. That was favorable. And I'm not saying that you have to vote for every one of them. I'm just saying that the article was pretty kind of embarrassing if you're going to get if that. And if you're in a mutual fund, those votes become public, right? Because you file on PX. Also, thing to think about is that it's unlikely this current administration and currently the way the Commission is constituted is going to bring those types of cases. But you know there are going to be changes in Washington at some point, and the statute of limitations will eventually run. But actions that you do or don't do today will be looked at 2 years, 3 years from now.
I would like to stop at this point and see if anybody has any questions or things they would like to add on proxy voting. Does anybody have any? Yes, Neil.
Just a question. You've focused a lot about executive compensation as underlying the effort by the Chamber and the National Association of Manufacturers to change the rules. To what extent do you think it is that it might also be sort of ESG related issues that make a lot of these folks nervous about the influence that shareholder activists could have through the ISS Glass-Lewis duopoly?
I mean, I think it's part of it, but I don't think, what's really scary to them. It's not limited to shareholder activists anymore. There are the large managers in large firms in New York that are now evaluating companies. I mean, it's controversial, but they're private investment managers. I had a presentation to a board and Counsel of a large ETF complex that is looking at sustainability as an investment threshold criteria, and this is going to affect. If this continues and if it grows at the scale it does, it's not the activists so much as a conclusion and its effect on existing business models. If investment managers, huge investment managers, start voting this way and not just simply of activists. The second thing I've also observed, again, counseling boards, is that managers of boards presenting skeptical directors with an ESG proposal and explaining that there is a demand in the marketplace for sustainable investing, that this is being driven not by activists who have a political agenda, but by investors who have an agenda. And I would suggest, since we're in Washington, we can be political, and I'm no longer working for the government, that when investors, a lot of people have a lot of surplus money around, and they'd like to do something with their money that they find useful. And if investors, affluent investors, feel that the government is not doing an adequate job to address environmental, social, sustainability issues, I think what's happening at a marginal rate and marginal amount, it's likely that people are going to investment managers and are looking at funds that will address that.
Yeah, Neil, I think you're correct, and I agree with Bob as well. I think that the issue you identify, the fear of the issuer community, is even larger than the proxy world. It is, as we sat there at the AMAC, we're talking about this issue, there was acknowledgement that 20 or 30 years ago at the commission, didn't matter what the political composition of the commission was, Republican or Democrat, there was a fairly strong view that things like environmental responsibility were not necessarily material pieces of information that needed to make their way into disclosures of public companies. Fast forward to today, and I think there's not universal, but near universal understanding that issues of environmental responsibility, social responsibility are very material to many investors, and that one of the bigger concerns for the issuer community is, okay, wow, that's a big, if we're looking at environmental responsibility, what's a material emission in that context? Or if we're looking at social responsibility, what's a material emission in that context? And I think there's a genuine fear of lawsuits, generally speaking, by shareholders, and then when they start to factor this layer in, I think it's scary for them.
Any other questions? Yes.
So I work for an advisor that most of our clients are Catholic institutions, and they vote. We use ISS to vote their proxies in accordance with their guidance, which is based mainly on U.S. Conference of Catholic Bishops. Can you kind of talk about how this new proxy voting guidance works with that?
Well, the SEC specifically addressed that, although not your particular genre. It said that, of course, advisors may vote proxies in accordance with their the proxy guidelines of their clients, and that's what yours is doing. And it's a little bit like the issue of directed brokerage. Do you know what I mean? And
right.
Is if your client tells you to use his brother-in-law, it relieves you of fiduciary responsibilities otherwise of using somebody who's perhaps not the best broker. And I would think that here, following the guidelines of the fiduciary issues for you would be to follow those guidelines of your clients, and not so much to worry about the general other issues that are faced with with an advisor that has essentially discretionary authority to vote proxies.
And do you think that's something that should be? I would say our contracts say that we vote, using ISS for this, but it's not something that it's specifically directed in a contract where the client says you should do this. Well, you say this is what we're doing.
Right. Then the issue, then I think in the guidance is the question is what is your due diligence obligations to see that ISS is following the guidance or guidelines, or is providing the guidance of advice to you consistent with those guidelines. That's what I would think.
Yeah, I think that last point that Bob just made is the really important point, and it's similar to the environmental responsibility. So the Commission brought up an action against Pax World funds a while ago because they said they were going to vote. They said they were going to invest and vote proxies in accordance with a certain platform of environmental responsibility, and they, their diligence efforts were very thin, and they didn't actually do that. So if it's faith-based or whatever the linchpin is to your particular, investors are there because they're interested in this, then you just have to make sure you're doing what you say. There's
another enforcement case, analogous, although the flip side, the money manager was managing money for labor union money mostly, but had some other accounts, and it managed all of the accounts, not just the labor union accounts, in accordance with ISS pro-labor guidelines at the time, and the SEC sued them for failure to disclose to the non-labor unions. They were voting in accordance with a set of interests that hadn't been disclosed to them. So that's exactly the flip of the PACS world.
So there's been some cases.
Yeah.
Unfortunately, I think we are getting to the end. I did want to just put in a quick point on DOL. I think that the main message there is there's more to come. We're still waiting for them to come out for something on Proxy. But with that, I would like to thank Scott and Bob for joining us today, and thank you all very much.